guys, I am super, uber, duper excited about today's episode of Live with RoQuanda Guy. Today, we're going to talk to a special guest that I'm super excited to talk to. Do you guys know in 2020, okay, over 312,000 homes were sold? And Florida alone. Okay. And the numbers for 2021 is continuously going up. So I can't wait to see what the numbers are. But there is steps from the time that you have an executed contract to the closing table. So today we're going to talk about what those steps look like. So I am super excited. I want you guys to stay tuned. You do not want to miss today's episode. Awesome and amazing. So today we have with us Mrs. Jackson, and I am super, uber excited to have her with us. She is absolutely a phenomenal queen. So Ms. Jackson, tell us more about you.
Well, my name is Racole Jackson. I am the founder of Title Experts. We are a full service settlement services and closing firm. We service all of Florida. I've been in real estate for, a very long time. I'm a licensed realtor as well. Done some work in mortgage, appraisal. So I basically love all things real estate. Right now, my primary focus is managing and operating our title firm, as well as providing coaching, mentorship, and training to our realtor partners.
Awesome. So tell me more about your title company. How long have you been in operation and who do you service?
So we've operated in the title space first through our law firm, Realty Law Group, since 2014. We launched Title Experts, which is a standalone title company, in 2019. So do the math on that. We primarily, our target audience, we service resale, new construction, refinance, individual private parties who are transferring title and need the assistance of and want to receive title insurance, and they also want escrow management. So that's our essentially our traditional market. We also obviously assist and we service people who are going through short sales. We do close those, and also any foreclosure REO sales as well. So.
Awesome. That's really exciting. So you guys are busy and you cover all aspects of real estate, helping individuals, regardless if they are represented by a realtor or if they decide to do it by themselves.
Absolutely. Absolutely. We get a good number of people who reach out. Like I said, independent, private homeowners, buyers and sellers who just they realize that they need an escrow agent. The buyer may want title insurance to facilitate the transfer of title and transfer of funds. And so we do conduct those transactions as well.
Okay, awesome. So from the time that we as real estate agents receive an executed contract and it is signed both by the seller and the buyer, and we connect with you as our title experts, take us through the steps. What does that look like on the back end? Because most people have no idea. They just show up at closing and we take pictures and we sign, but we know that there's so much more that happens. Can you take us through that process, please?
Absolutely. So one of the first things, I'm going to go through the process, assuming that it's a finance transaction, meaning that there's a lender involved in the transaction, because the process is just a little bit different when a lender is involved. Specifically, when the file comes in, one of the first things always is being asked for is wire instructions. So one of the main points that I want to make, and I'm sure that if you have not heard this, you should know that wire fraud is still an issue in the industry. And the reason I bring that up is because oftentimes one of the first things that we're being requested is to send wire instructions to the buyer. And that we do, but we do it under a particular protocol. That is, we utilize a proprietary or we use a settlement software that allows us to communicate with parties securely through a portal. And so our communications can be secure, and it provides for the less likelihood or possibility of hacking. With that being said, once the file comes in, we open a file. And so because we do process a lot of files, we do have a very streamlined process where a file is open, our information requests start going out to the parties. But one of the first things that goes out is the wire instructions. And the wire instructions go out asking the buyer to create a login and a password. And so I have to stop there because, again, in times past, realtors will say, oh, can you send me the wire instructions to send to the buyer? Listen, you do not ever, no one, whether you're the realtor, the lender, whomever, do not attempt to be the middleman for wire instructions. Because if there is an issue, you never know. You don't want to be trying to backtrack and say where the breach occurred. Okay. If you know that the instructions went directly from the title agent to the buyer, then there's only two places where there could have been an interception in communication. So that's one of the first things that we do. We deliver the wire instructions, and we make sure that we establish a protocol that from the earnest money deposit and to any other wires that are made during that transaction, that they know to call our office and confirm wire instructions.
Okay, so let's stop there. So wire instructions will go to your office twice. Okay, so if you are the escrow agent, okay, depending on the contract, usually it's 3 days, they will reach out to you, make that connection, and then they will transfer their wires or their monies from their account directly to your account. Is that correct?
Of course, yeah. And then obviously that's not to say that they can't make their earnest money deposit via check, cashier's money order. One thing that we don't, and I'm sure probably other title agents don't accept, is cash. And so, those are other means of making your earnest money deposit. It's just most times it's going to be a wire. And so we want to be sure that we're clear on the best way to securely and safely make that wire deposit.
Awesome. Okay, so the first thing is we have an executed contract. They make their initial escrow deposit. And then what happens after that?
All right, from there, it's time to pay attention, watch your email, answer your phones, because there's gonna be a lot of action taking place. One of the first things that we do, like I indicated, is we initiate our information request. Realizing again that in a traditional transaction, you're gonna have your buyer, your seller, you're gonna have your seller's agent, your buyer's agent, you're going to have a lender. And so on our side, when we open the file, we start sending out information requests. An information request is simply vital information that we need to create a file to begin underwriting the file for closing. We're going to send information requests to the buyer. We're going to send to the seller. We're going to send to the listing agent and the buyer's agent. From the buyer, we're going to be asking them who's going on title. We're going to be asking for contact information. We're also going to ask them to confirm their lender's contact information, because we're also sending information requests to the lender as well. To the listing agent, to the buyer's agent, we're asking them to confirm their buyer's information. In the event that there's something that they might have left off, we're asking them to confirm commission. We're asking them to confirm their brokerage information. To the seller, we're asking them to confirm their contact information. We're asking them to confirm payoff authorizations, because sometimes they have mortgages that need to be paid off. We're asking them to provide and confirm their social security number. I want to stop and put a pin there. That's important information that must be provided. We are required by the IRS, Internal Revenue Service, to report the sale of real estate. The sale of real estate is what they call a taxable event, unless there are exceptions. We do sometimes, obviously, people are concerned about information fraud and hacking and such, and they're not always willing to readily provide their social security number. But one thing I will say is when we don't receive a social security number as a title agent, we must assume that the seller is foreign, that there may be a chance that the IRS will not receive their taxes at tax filing time. And if that is the case, we are responsible for withholding on average about 15% of the sales price.
Wow.
Exactly.
That's huge. I'm glad you stopped there and put a pin. So it's very important. Okay.
It's very important to understand that. And so that all falls under the topic of it's called, the acronym is FIRPTA, Foreign Investment in Real Property Tax Act. Foreign Investment in Real Property Tax Act. Again, that requires that we receive a social security number or tax ID number if it's an entity from every seller to confirm that they're not foreign. Why? They want their taxes. If you're foreign, they want their tax money. And if you're foreign, it's likely you can go abroad and they never hear from you again. So that's something that I want to be clear about. And we get questions, why do I need to give you my social security number? This is why. And if you don't, it's fine, but we have to withhold 15% of the purchase price.
Wow.
Not the proceeds, not what you get after all the closing costs are deducted, but the purchase price. And generally, once we explain that, we kind of get past that and we don't have to have that discussion anymore. So that's what we're collecting on the seller side. On the listing agent side, same thing, contact information, confirming broker, confirming commission. With the lender, we have our process with them where they start requesting title information so that they can do the underwriting on their loan. From that point, on the title side,
when you say title information, what does that look like?
So they're asking for the lenders send generally within the first 24 hours, sometimes same day of the file coming in, they're going to send what's called a lender's title request. And that title request asks for a few specific things. One, they're asking for, most importantly, a preliminary closing disclosure. And this gives them the ability to collect what our estimated title closing costs are so they can get out to the buyer a preliminary closing disclosure for financing purposes, right? And so they take our title figures, add their lending estimated costs, and they get that over to the buyer. That's one of their most important first documents. Outside of that, they're going to ask us for generally 24-month chain of title is what they call it. And that's asking for the chain of title of ownership on that property from 24 months as of today's date back.
Okay.
Then they're asking for what's called a closing protection letter. That's just protecting the lender, saying that in the event that there's any financial loss, we can cover it. Because at some point, they're going to be sending us, a couple $100,000, in some cases, $1 million. So we send them what's called a closing protection letter. We also send them the title commitment. When the file is just open, we wouldn't have that. It takes about 3 to 5 business days to obtain a title commitment, but that is one of their requests. And as soon as that is received, we send that over to them. They're going to ask for the survey once we have that in. And that's pretty much what we call their title, the lender's title request. And again, we provide them what we can provide them within that first 24 to 48 hours, and everything thereafter that we provide it to them as it comes in. All right.
So can a buyer select their own survey company, or do they have to use one that the title company recommends?
They can absolutely select their own survey company. We do have survey companies that we work with, just simply by virtue of cost, reliability, and the work that they do. But if a buyer says, well, we have this particular survey company that we like to use, they're absolutely able to do that, as long as they can provide the surveyor can provide a survey that is sufficient for title needs.
Okay, perfect. So once all that information is gathered from the buyers, the sellers, the buyer's agent, the listings agent, then the information is provided to the lender. What happens at that point? You guys just sit and wait for the
Oh, absolutely not. That was just getting everyone in their seats. Now it's time to run the searches, right? And so we're going to order a lien search. And the lien search is going to do a search of the property. It's going to report back to us any water bills, any code violations, any open permits, any tax violations, if there are any open taxes on the property, in those types of municipal situations or issues that need to be addressed as it relates to the property. We're also going to order a title commitment. The title commitment is doing a search of the title to the property. Generally, with that search, we're confirming who does the property appraiser show as the record owner of the property. We're making sure that who you guys have introduced as a seller is who title shows as a seller, right? We're also making sure if there's any mortgages on the property, liens come up in a title search, any prior title issues, if there was a deed that was executed with an issue, if there was a mortgage that was not paid off or satisfied, or might have been paid, but a satisfaction of mortgage wasn't recorded. If there are any defects, our examiner is looking at documents that are recorded in what we call the chain of title. And if they find any defects in the documents that are recorded, it's going to come back to us as a requirement on our title commitment. So that's a lien search, title search. If the property is located,
for you,
go ahead.
cut you off. But say, for example, if it comes back and the wife or the husband is now deceased, and the living spouse wants to sell the property, what happened at that point? Or what happened if their name is never on the actual note, and now they're trying to sell the property because they just lived there forever and ready to move on? What happens? What does that look like?
So that's a good question. If the deceased spouse, that is one of the first things that we do. We look at the deed. And if the deceased spouse was on the deed, title to the property, either as husband and wife, joint tenants with right of survivorship, the only thing that's necessary at that point is to record a death certificate, and the interests are automatically transferred to the surviving spouse or other surviving party on the deed. If in the event that there is not that's called vesting language, in the event that there isn't husband and wife, if you have husband and a wife, there's an assumption that in the event that either spouse dies or passes away, that their interest transfers automatically to the surviving spouse. Similarly, you cannot be married, and if you use the language joint tenants with right of survivorship, it means that whoever survives the other deceased party, they're going to receive automatically the the ownership interest that the deceased party had. So using your specific example, if it's a husband and wife, if that language is on the deed, we're recording a death certificate, interest passes. If that language is not on the deed, then the seller will have to go through a probate proceeding if they have not already.
Okay, and I want you to finish, but another question I get all the time, where you may have a husband that has perfect credit and the wife does not, or vice versa. And how does that look? I mean, a lot of people are concerned to having their spouse on the title by themselves. And we talk about Florida, how if you're married, that spouse name automatically goes on. But can a person actually purchase without their spouse? And can they sell without their spouse knowing?
That's a good question. So in the instance of purchasing, you can have a spouse not be on the loan just by virtue of the fact that they don't have good credit. And if you have one of the parties that has sufficient credit to justify a mortgage loan without the other, then you can absolutely do that. Now, what's going to end up happening as it relates to title, the non-borrowing spouse can still go on title because that goes to ownership interest, assuming the lender has no issue with it. Generally, they do not. Even if the non-borrowing spouse does not go on title on the deed, if it's individuals that are purchasing the property, title is going to require that the spouse sign the mortgage, because like you said, in Florida, you automatically get what's called, or you cannot automatically, but you can have what's called a homestead interest in your property. And so what we have protection is you can't take our house away from us on various forms of debt, except for those that you've specifically agreed to. And the mortgage is one of those things. And so your homestead interest is protected. And so the spouse, even if they're a non-borrower, when they live in the property, they have a homestead interest that's protected until default. And by signing the mortgage, you are affirming that you are aware that you are placing a lien on your homestead interest in this property. And in the event that you do not make payment, that the lender can foreclose. So that's in the instance of a purchase, when a husband and wife is purchasing. When a husband and wife is selling, if the property is their homestead property, husband is the only one on the deed. No, that's wife is the only one on the deed.
I like that. Let's change it. Wife.
Wife is the only one on the deed, but wife is married. If it is wife's homestead property, then husband needs to sign the deed to transfer out his homestead interest in the property. It's the same thing. We're concerned about the homestead interest. If it is not wife's homestead interest, this is an investment property. It's something that she had when she was single, came into the marriage with it. She's been renting it out since then. Then husband does not have to sign the deed, but title agent will include language on the deed that says this is not the homestead property of wife. Wife's homestead property is 123 Main Street.
Okay. So I know what that means, but for those individuals that's watching us right now, we have quite a few people watching us. What do you mean by homestead investment or property?
Well, homestead is your personal residence. That's where I live. That's what's protected. Again, that's what's protected against foreclosure, involuntary seizure. Versus an investment property, you do not live in that property, so it's not protected. In Florida, you can have one homestead property. You can't have three. Okay. And so that's the difference. If you have, even if you try to report that you have multiple homesteads, you cannot. You have one homestead property, and the rest of them are investment properties. The rest of them are up for grabs, right? And then one other point I want to make, which is important because it comes up sometime. If someone purchases a property as an investment property, you're purchasing as an investment property. But if you're purchasing as an individual and you're married, the closing agent should still require that the spouse signs the mortgage, because our underwriter's position is that you can change your mind at any point and say that this is your homestead property. It doesn't take anything but to make that declaration. And now all of a sudden we're having a conversation, lenders having a conversation about having to foreclose on a property that you did not sign the mortgage on. Does that make sense? And so, they come in and say, well, this is, that's an investment property. Well, my underwriter's position is you can change your mind tomorrow and say, you know what, this property is actually better than ours. So let's move into that one. And now we're having a conversation about what your homestead property is. Now, contrary to that, in the opposite situation, if you're purchasing as an entity does not have a homestead. And in that case, no other signature is required, or no spouse's signature is required.
Okay, perfect. All right. So now we've moved on. Okay.
That's you asked. You want a lesson in title?
That's a lot for title.
You gotta be a title expert before this time is over.
Oh. Okay, now, so we have the executed contract. We have the buyer's information. We have the seller's information. It's just me recapping. I'm the educator. Yeah. And
you have the earnest money deposit. You have the title search.
Deposit. We have the title search. All the names are good. We have the lien search, you said. Now, what happened if it come back if they have some liens on a property that they had some improvements, but they never closed them out? What does that look like?
So that's a good question. Two things. If it's a code violation, then it must be cleared out. Code violations are title issues that must be cured prior to closing. If it's an open permit, permits are not title issues. We can close with open permits. The requirement to close an open permit occurs when the purchase contract has in it additional language that specifically says seller will be responsible for closing out all open permits at their expense prior to closing. Our standard Florida FAR Bar as is contract was recently, well, not recently, but in the last few years, it was revised to exclude or remove the seller's requirement to close out open permits. That language is no longer there. And so now to address that, what you'll commonly see is that language added to the additional terms section that the seller will close out all open permits and code violations at their expense prior to closing. If that language is there, we're notifying the properties, you have open permits, let us know how you want to address it. The parties can decide once they're moving through the transaction, they can decide, that's okay. We know what that open permit is for. We're not concerned with it. Fine. For our documentation and for our CYA, you're going to sign a hold harmless and a disclosure that you were aware that there were open permits on the property and you decided to proceed to closing without it. Again, they're not title issues, so we're not going to hold you up. Code violations are, open permits are not.
Awesome. All right, so we got that. We are clear, good to go. We don't owe the city any money at all for any violations. I had one in Miami that it was $1,500 a day.
Oof.
A day. Yeah. So we clear all that up. So then what is the next?
What was that? Oh my God, 15. I've never seen one for 1,500.
It was crazy. Absolutely crazy. So what's the next step?
Next step, if the property is located within a homeowners association, or condo association, we're ordering an estoppel. The estoppel is going to notify us if there are any violations, HOA violations or condo association violations. And it's also equally important going to give us an account and ledger of the of the property. It's going to confirm what the dues are, if any. It's going to tell us what needs to be paid. It's going to tell us if there's a capital contribution. It's going to tell us if there are special assessments pending, special assessments due, what's the monthly rate, et cetera. And so we use that for those two reasons, including also it will let us know whether or not HOA approval is required on the property. So those are three things that we look at with the estoppel: whether or not HOA approval is required, what is the balance on the accounts for the property, because that will be added to the settlement statement. And then finally, if there are any code violations, because that goes to title.
Awesome. Now, if there are the code violations, how is that taken care of? Does the seller have to pay that ahead of time before closing, or is that taken care of during the process?
It depends. And so we would need confirmation. We've had, so like, for example, in your case where you have the one that was accruing a penalty of $1,500 per day, that could be the sidewalk.
Miami Gardens.
Oh, I was anyway. That would be addressed. Generally, you're going to cure the violation. You're going to cure whatever the problem is, right? So you have the problem and then you have the cost of the violation. You're going to at least cure the violation. You're going to stop the bleeding, whatever it is that's causing the property to incur this cost. You're going to address that. And at that point, you can obtain from the city or whomever the enforcing agency is a payoff letter to say this amount must be paid, and they can be paid at closing. After they're paid, they will record a satisfaction and release of that code violation. That happens most times. Sometimes it needs to be paid before, but most times you can at least cure it and then make the payment after.
Awesome. And with some properties, if it's a condo association, senior citizen community, a lot of times you have where on the actual closing disclosure where they pay your HOA fee for a couple of months. Is that standard?
Well, it happens. And so in that case, you're going to see what is called a proration. And in that particular case, it's going to be a proration credit. So you're going to get a credit to the seller for the amount of association dues or whatever costs associated with the property that have been paid in advance of, or that's paid beyond the closing date. So okay. It's not uncommon.
All right. We have to have another Facebook Live to talk about prorations with taxes and stuff. That can go on forever and ever. Amen. So tell me, what is title insurance and do I need it and who pays for it?
So title insurance is just, as I say, similar to, I'm glad you asked that question. It's similar to health insurance, car insurance, life insurance, in that it is insuring your title to the property from the date of ownership back. This is important. From the date of ownership back. So we're saying, we are promising you that no one will come up saying, hey, we have a mortgage that was not paid off, or I actually own this property, not that person that signed the deed. So we're giving you insurance that none of those items will occur. And in the event that they do, we will indemnify you, we'll protect you, we will clear that up. Should you obtain title insurance? Absolutely. Real estate is one of the largest investments that you're ever going to make in your life. You don't want to potentially lose your ownership interest in the property for a couple hundred, maybe even a couple $1,000, depending upon your price point. So it's something that you definitely do not want to forego obtaining at closing. Who pays for title insurance is negotiable. It's something that is agreed upon by the parties. You know that on our standard FAR contract, we have three options standard for who pays for title insurance. We have 9C1, which is buyer's going to select the title agent and pay for title insurance. 9C2, where seller is going to select the title agent and pay for title insurance. And then we have 9C3, which is called our Miami-Dade / Broward provision, which is where the buyer is going to select the title agent. The buyer is going to pay for their owner's policy, but the seller is going to pay for the cost of the searches, being the title search and the lien search. So it's kind of what I call a split the baby. But that's where you land, where deciding who's going to be paying for the owner's policy. Generally, the buyer is always paying for the lender's policy. There's two policies that are issued at closing. There's one to the buyer. Their rate of coverage is the purchase price. They purchase a property for $1 million, they're going to get $1 million in insurance coverage. The second policy that's issued is to the lender, and it's going to be for the loan amount. You purchase a property for $1 million, but the lender gave $800 in financing. Their policy is going to be for $800,000.
Thank you for clarifying that. Most people don't know that information. I'm excited about that. All right, so what is the next step? Because I'm really excited about moving into my $1 million home.
Well, one thing I'll clarify. So, and as it relates to our office, those are all the searches that we would have done. We would have done the title search, the lien search, and the estoppel. Now, at the same time, I would hope that the parties are aware that on the realtor side, on the transaction side, outside of our office, simultaneously, there's going to be the property inspection is taking place where the inspector is inspecting the structure. They're inspecting the house. Understand that title insurance, although our system, for example, allows us to see due to satellites, we can see the property, but we can issue title insurance sight unseen because we're insuring title. The property could be 3 walls with the roof leaning on the ground, and we're like, okay, here's your policy, it's yours. No one's going to try and take it from you, right? So we do not inspect the structure. So simultaneously to our searches, you have your property inspector that's going out there and is actually inspecting the structure. Additionally, after that, you're going to have our surveyor. We're ordering the survey. Our surveyor goes out. The surveyor is inspecting the boundary lines of the property, making sure that the property sits within its boundary lines, that the pool is not over the boundary lines, that a fence is not over the boundary lines. And it brings back to us a drawing, a sketch showing where the structure is within the lot. And then it also reports back if there are any what we call encroachments or easements that may be of issue in the property. And so generally we don't have any issues, right? Sidewalk over is encroaches on a FPL easement. That happens. It's not a big deal, except that there may come a time when FP&L is going to come and try and dig up the sidewalk in front of your house to deal with the lines. That's the thing that you need to know. Now, if it comes back and says that the pool is 3 feet into the neighbor's yard, that's a problem. And it needs to be addressed. The parties can agree to accept it that way. Here's another caveat for you. When I say parties, the buyer and the lender can agree to accept the property that way. It will be an exception. It'll be an exception from their coverage, though, so that when the owner when the neighbor comes, should the neighbor come and say, "Excuse me, that pool, you need to move it back 3 feet." Should they come and say that, you can't come to us and say, "Wait a minute, you never told me that my pool was 3 feet over the boundary line." We're going to say, "Yes, we did. Here's your survey. And here's the policy showing you that was excluded." You're probably not even going to get to that, because once he goes to the lender's going to say, "Oh, that's a problem." And even though the buyer is saying, we're going to use, for example, this market where there's no inventory, and the buyer's saying, "It's okay. Like, what's the likelihood of them saying anything? Like, there's no more houses in America ever." The lender's going to say no, because you got to understand, when you are financing your purchase, you and the lender are partners in this, right? So whereas you may say yes, the lenders might say, no, we don't. No, we're not okay with that, RoQuanda. We're not. So that's something to understand as it relates to the survey. But like I said, generally we don't have that issue. Survey comes back with traditional, like I said, sidewalk is over the FPL, fence is close to the line, those types of things. And so that's the survey examination. And then one of the other examinations is obviously the appraisal. That's when someone is going out, the appraiser is going out, and he's inspecting the property to confirm that the agreed upon purchase price is supported by his market analysis. And so he's coming back and saying, yes, this property does have a market value of $4 million. So you generally have, as it relates to inspections, whether they're being ordered by our office, the appraisal is ordered by the lender, the property inspection is ordered by the buyer. So you're going to have title search was an examination, lien search, estoppel, survey, property inspection, and the appraisal. So a lot of examination going on.
So you have a lot of examinations going on. Say that it comes back and is not what the buyer expected.
as it relates to what condition or
Condition, value, or even say, for example, one person in our office, they listed 11 acres and they came back, it was only 9 acres.
Ooh.
So we're now in a contract and the buyer's like, hold up, this is not what I agreed upon. I want my escrow back.
They can.
What happens at that point when the seller says, I'm not giving you my escrow, but you're holding escrow? How do they determine who gets the escrow back?
So we don't determine who gets the escrow back. The only time we release escrow is when we get a fully executed release and cancellation of the contract and releasing the escrow to whomever the parties have agreed to release it to, whether it be the buyer, seller, someone's best friend, whomever, but it must be the buyer and the seller signing the release and cancellation. In the event that there is not a completely executed release and cancellation, we're going to consider that to be a dispute. And you guys are going to follow the dispute resolution process as you've agreed to within the contract.
I like that answer. Good job. All right, so there's no dispute. Everyone is still in love with each other. We are moving on. We're getting closer to the closing table. I can't wait to hold the key. Now tell me, what else do we have to do?
So the next step, once the searches come back clean, we say title is clear. We resolved all title issues. From that point, we're working on the settlement statement. So we are what we call, you probably heard the term matching and balancing. We're receiving from the lender their title and their lending costs. They're sending those to us for us to enter them in the system. We're sending back to them our title costs, recording costs, taxes and such on our side, and they're entering in their system. And what we're saying is, okay, we match and we balance with what we're calculating to be the closing costs, what we calculate to be the anticipated cash to close, and what we anticipate to be, all the different numbers and payments that are due to the parties. So that's matching and balancing. And so a point that I want to make there is to be clear that for buyers specifically, keep an eye on the settlement statement. The title agent does not determine your loan costs. We have about 5 areas of expenses that come from us. Everything else comes from the lender. And so if there's any questions about why is my interest rate this, or why is my cash to close this, talk to the lender. We just receive and report.
I was to ask you that question. If there was any discrepancies, they need to talk directly to.
Oh, absolutely. We don't. I mean,
call the title company.
Yeah, like I said, we got about 5 areas on that settlement statement that we provide those costs. But outside of that, all the other costs are come from the lender, or their premiums that are even our title insurance rate. That's promulgated by the state. Everybody charges the same for that policy. Settlement fees differ, but the promulgated rate for title insurance itself is set by the state.
All right. So we've signed the disclosure. Everything matches. You guys get everything in the CD.
Now it's time to prepare for closing.
Okay. What happens then?
It's time to prepare for closing. So one thing I want to say to be clear too, because clear to close, we had to get this clear. When you receive a clear to close, that's similar to going under contract again. I just want to say that to set your expectations. That just because you got it clear to close doesn't mean you're coming to our closing table in 30 minutes. Like that just triggers a whole nother process. And that whole other process is the matching and balancing with the lender, the getting the documents from the lender that will need to be signed, the scheduling the buyer to sign, to confirming their cash to close amount, sending them wire instructions again, confirming wire instructions again for them to send in their cash to close, right? And so it's a process. And so just hearing clear to close, it's a definitely one of your last hurdles. But again, it's not the finish line. The finish line is after those things are taken care of, you have a scheduled signing with the title agent. On the seller side, we do what we call pre-sign our sellers, meaning once our title issues are cleared, we know that we're clear on what the seller must do to clear title. We'll prepare their documents and have them sign in advance. They can sign either in our office. They can sign via sending a notary to them going to their own notary. And we also do remote online notarization. That is them signing online, like DocuSign, but with the camera. It's not FaceTime. That's a whole nother conversation.
In order someone's coming to your office, what do they need to bring with them?
For a seller, they just need to bring, basically, they need to bring their ID and bring a blank check so that we know where to send your proceeds. For a buyer, they're going to need to bring their ID as well. It usually should be about 2 forms of ID, because that is a document that we complete at closing. Some lenders require 2, some require 1, so it's best to have 2. And then they should also bring their proof of wire. Some lenders require for once they sign, there's a process called funding approval, and that's where all the documents that the buyer has signed are going to be sent to the lender. The lender is going to review those documents to confirm that they've been signed properly, and then give us approval to fund the loan. So that's the funding approval process. And so to speak specifically to that, once you're scheduled for closing, this is not a lunch break appointment. And this is not something that you're going to be able to, it's not something you're going to be able to complete in 30 minutes. You're probably going to be signing for 30 minutes at least. And then again, from there, the documents have to go to the lender. And although this is a very momentous day and it's a special day for our buyers, there's like probably 10,000 other buyers that same day at that same time. And so when we send our package to the lender for review, someone else is probably sending their package to the lender for review. So that's just to say that we have to pack our patience and give them the opportunity to review the package to confirm that all the documents have been signed properly and that we can disperse funds. We try to make that whole wait process as painless and enjoyable as possible. We do stock our closing room with snacks, coffee, water. If you have kids, we have crayons and coloring books. We have TV, just because it's a huge occasion, and we don't want it to feel like you went to the dentist's office. It's not even a marathon; it's a sprint. To go from contract to close is a sprint for sure. And so we endeavor to have them feel like they're at the finish line with all the celebration for completing that process.
I love the celebration. All right. So tell us, where can they find you? If you have an individual, we have some realtors that's on here. They asked a question. I'm not sure what the question is saying, but in the event that they want to reach out to you, what's the best way to reach out to you? By email, phone number? Give them your information.
So our website is www.titleexperts.com. That's TITLEXPERS.com. You can reach me at Racole, RACOLE at TitleExperts.com. And there is also the office number, 561-510-2294. Any of those, I'm also on social media at Racole Jackson. There's a website. There you go. So any of those different ways.
Awesome. Thank you so much for your time. I ran over like 10 minutes, so please forgive me, but all of the information that you provided was absolutely amazing. And I think this is information that both sellers, buyers, and new agents need to know, because a lot of people don't understand the process. And like you said, it is definitely, a process that's filled with a lot of emotions, and having information that is vital to the process as you go through, making sure everyone's on the same page. And it's a team effort. Everyone has to be able to communicate effectively. So
I think I have a recording on our YouTube page of the closing process, potentially. So check out our YouTube page, Title Experts, and there's a couple videos posted there on the closing process, some other realtor trainings, and also what we call anatomy of a transaction. So contract, we just discussed contract to close on the title side. We have a discussion on contract to close from the realtor side. That's housed on our YouTube page for sure.
Awesome. And I'm going to share that information below as well. Awesome. I'm just checking to make sure there's no other questions. We're good. Thank you so much for your time. I agree.
Thanks for having me.
Thank you.
All right.